Okay. All right, and Xiomara is with the Small Business Development Center at PCC. She's one of the advisors. She has a paid job as well, but she is with the PCC Small Business Development Center. And for those of you who don't know, that's an organization that's funded in part by the Small Business Administration, and they provide all kinds of free one-on-one advising confidentially to putting on seminars and webinars on everything from developing a business plan, starting a business, funding your business, financing your business, all the way through to when you have to close your business, sell it, succession planning, etc. So without further ado, Xiomara, it's all you.
Thank you so much. It's a pleasure to be here with you all this morning. Let me go ahead and share my screen. And if you can just give me a thumbs up when you see it.
Yep, good, you're good.
Great. Okay, good. All right, everybody. So thank you all for joining today. I'm gonna go through a brief overview of new employment laws here in the state of California. As many of you may know, every year, or at least twice a year, we get new laws and that impact bigger organizations, but also are becoming more stringent and applying to small businesses. And thank you, Lori, for that introduction of the SBDC. You know, one thing I want to mention too is that we provide all those services Lori mentioned, also for startups and existing businesses. So it doesn't really matter if you are just starting your business or if you are already established and looking to grow. Furthermore, all of our services are provided at no cost to anyone, to any business owner in need. And a little bit about myself. I've been in human resources for about 15 years now in counting. I'm also a small business owner of a consulting firm called CALsavers HR. And I'm also a resource at the SBDC should you need to reach out for any questions or a consultation, or if you need to reach out to anyone else, feel free to email us at sbdc@pasadena.edu. So without further ado, let's cover the agenda, what we're going to talk about today. So I'm going to give you an overview of labor law, what of the latest OSHA emergency temporary standard is, and actually that is changing in just a few days. We'll go through minimum wage requirements, COVID-19 supplemental paid sick leave, and we'll cover a few upcoming compliance requirements. And last, as Lori mentioned, we'll close it out with Q&A at the end. And I'll try to answer as many questions as I can. But if I don't get to your question, Lori is going to be collecting all those questions and I will be following up with some answers that she can share with you at a later time. Just a brief disclaimer, what we cover today is up to date. As of today, as you know, human resources is ever evolving. So some of the things that we cover today might be changing or may change in the near future. So just keep that in mind. What we do cover today is up to date, is the latest and greatest as of today. All right, so let's dive in. Starting out with one of the laws that went into effect this year, SB 807, which requires to change the record retention requirements for employers from 2 years to 4 years. And this law is really a sequel to a law that went into effect a few years ago, back in 2019 or 2020. We had a law that changed the statute of limitation for employees to file a complaint with the Department of Fair Employment and Housing for anything related to discrimination or harassment. And this law was implemented to really align with that statute of limitation for employers to maintain records now up to 4 years, or if there's already some kind of litigation or a claim going on, the employer is now required to maintain those records through the end of the litigation. We also had SB 657, which essentially allows or makes it official to allow employers to distribute posters and notices electronically as opposed to only having them physically. So with COVID-19, many workers were working remotely and employers were tasked with having to figure out how they would comply with the distribution of making posters available for employees to notify them of their rights in the workplace. So this law really makes it official that employers are allowed to distribute those notices and posters electronically, but it also maintains that physical posting requirement. And one thing that one flaw of the law is that it does not specify which notices. As many of you may know, there are posters from different agencies, for example, from the Department of Industrial Relations and also from the Department of Fair Employment and Housing, but the law is silent as to which notices are allowed to be distributed electronically, and it does not change the federal posting requirements as well. So safest thing to do is to have them physically if you have a location, or if you have employees that are on the road, maybe having them in a binder and have them with the employee at all times, but also disseminating them electronically would get you in compliance as well. Now, this law, we might have a lot of questions on this. This law was California Family Rights Act expansion. It's something that went into effect last year. As many of you may know, the law applied to employers with 50 or more employees, but as of last year, it changed drastically. It began applying to small employers with at least 5 employees, and it changed a lot of the eligibility of the law. So it expanded the family members for which an employee can now take a leave of absence for up to 12 weeks to include grandparent, sibling, and grandchild, and also parent-in-law. However, there was a mistake in the law last year, and they inadvertently left out parent-in-law from the language of the law. So this year, they have submitted a revision to the California Family Rights Act to clarify that parent-in-laws are included in the family members that employees can actually take a leave of absence for up to 12 weeks. Another change of the law, or quite a few changes of the law, was that it expanded the definition of child. So previously, a child was anyone under the age of 18. Now, child is a child of any age that an employee can take a leave of absence for to care for someone, to care for their child. It also left out, it had a provision that an employee that was considered to be part of the top 10% highest paid employees, there was an exemption of the law as far as job protection. It did away with that, and it had several other carve-outs. But the main reason, the main thing that went through for this year is that it clarified that parent-in-law is actually a family member that is covered under the law. There was also another sequel law to discrimination, retaliation, and harassment. A few years back, we had this similar law that went through to restrict provisions on non-disclosure provisions on agreements, settlement agreements or severance agreements for employees that allege harassment in the workplace. So essentially, if you had an employee in the workplace that alleged harassment or filed a claim or was close to filing a claim, or whatever the situation may have been, many employers would have been known for providing either settling the claim and providing an agreement that the employee couldn't disclose the conditions, the terms and conditions of those agreements, including the amount that they have settled for, and including the reasons why they had settled. So this law, what it did is it banned those provisions from agreements. So essentially, an employee could disclose why they were settling and the amount that they were settling for. That was for sexual harassment. So now the law expands to include anything related to discrimination and retaliation. Anything that the Department of Fair Employment and Housing considers a protected category. And a protected category can be anything like age, race, religious creed, color, national origin, ancestry. You see them on the screen. All those categories are now protected, and an employer can now not include any non-disclosure provisions in settlement agreements to prevent individuals from disclosing the reasons why they have settled on a claim, or they have settled on a litigation. They are still allowed, the law does allow for them to disclose the amount that they settled for, but it also includes specific language or sample language that employers can use to include on agreements. So employers can include a provision that states, nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you may have reason to believe is unlawful. So need to be very careful. Employers need to review all their agreements that they currently have and make sure that there is nothing in them that prohibits employers from disclosing or anything that states or speaks to the fact of disparaging an employer or anything like that. Up next, we had quite a few laws that went through on the wage and hour section of the law. We had SB 572, which expands the Labor Commissioner's authority, and it basically gives the Labor Commissioner the authority to place a lien on real estate property to cover for penalties owed for violations of the Labor Code. We also had a law that created a joint employer liability for contractors for unpaid wages and benefits, and also for any unpaid unemployment insurance and workers' compensation benefits or liquidated damages or penalties that a subcontractor would owe to their employees. So essentially, if you are a licensed contractor and you subcontract with someone, you want to make sure that that person is in compliance with all the law, because if not, then potentially the Labor Commissioner may come after you and hit you with penalties and liquidated damages. What some of the penalties are, for example, for workers' compensation benefits or not having workers' compensation insurance for your employees, it's a $10,000 fine for employers, or it could go up to $100,000 depending on the employee count that you have. So it's very important for contractors, if you're a licensed contractor, to make sure that whoever you subcontract with, they are covered with workers' compensation insurance, they are in compliance in paying their unemployment insurance, and they are paying their employees in accordance with the law. And one tip I'll share with everyone, just because I've seen a lot of things in the nature of my work, is that contractors should verify workers' compensation insurance directly with the company that the subcontractor is providing the certificate from. Because a lot of times what will happen is, or a lot of times, sometimes people will, this is what they will do, is they will sign up for workers' compensation insurance, they'll get their certificate, and then a month later, they will cancel the insurance. However, they have that certificate that shows that they had just either renewed their policy or gotten workers' compensation insurance. So that's one thing for contractors to keep in mind, is to always verify workers' compensation insurance every time you subcontract any work. There was also AB 1003, which added wage theft to the penal code. So now the intentional theft of wages is considered grand theft. If an employer does not pay an employee an amount of $950, or owes an employee an amount of $950, or $2,350 for 2 or more employees in a 12-month period. And one thing to keep in mind is that independent contractors are also protected from the law. So a lot of times independent contractors are exempt from the employment laws, because as an independent contractor, they're required to have their own workers' comp insurance, and they are able to manage their own time and, be operating on their own. But this law applies to independent contractors as well. and redefines the definition of employer to include the hiring entity of an independent contractor. So many of you might do business with independent contractors. So it would be good to make sure that you have at least an agreement with them, clarifying that relationship, and making sure that they are truly operating as an independent contractor, and taking a close look at that relationship. And just as a brief recap, right? I'm not sure how many of you may be familiar with the ABC test. Prior to the pandemic, what we had in California as center stage was AB5, which codified the ABC test into law. And prior to the ABC test, California used to have a different test to evaluate whether an individual was an independent contractor or not. And now what this law did back in 2020, AB5, was it added an additional test, and it made it nearly impossible to classify anyone as an independent contractor unless they meet all the criteria from the ABC test. So A, the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. B, the worker performs work that is outside the usual course of the hiring entity's business. And C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So if someone meets all these criteria, then they can be exempt from AB5, right? But it doesn't make them exempt from the original independent contractor test known as the Borrello test. So if you have someone that meets all these criteria, so A, B, and C, then now you have to go to the Borrello test and see if they actually meet the independent contractor criteria. So it's very complicated when it comes down to classifying workers as independent contractors. So I highly suggest you reach out to a professional or even an attorney, because it's a very, very murky area of the law. It's very gray. There are exemptions that were issued from AB5. This law here, AB 1561, actually extends some of those exemptions through December 31st, 2024 for licensed manicurists, construction tracking work performed by a licensed subcontractor, data aggregators and research subjects, claims adjusters, third-party administrators, manufacturer housing salespeople. So again, AB5, what it did is with that ABC test, it made it nearly impossible to classify anyone as an independent contractor. And ever since the law passed, there have been other laws that have passed with more exemptions, because people are just so flabbergasted that they're no longer able to operate as independent contractors. Last year we had a law that passed, AB 2257, I believe, which basically provided more carve-outs for the music industry to producers, because they were, in accordance with the ABC test, they would have been considered employees. So so that last year there was a law that passed that provided exemption from the ABC test for them. We also had a revised COVID-19 notification change that went through last year in October, that requires all employees to be notified of a workplace COVID-19 case. Previously, it used to be only those employees that were considered exposed, but the actual official language from the law is that all employees who were on the premises at the same work site as the qualifying individual within the infectious period must be notified. And the notification also applies to benefits and the disinfection plan the employer will be implementing following OSHA standards. And this is set to expire as of January 1, 2023. There were a couple of changes with OSHA enforcement. There was a law that passed that created two new categories for violations for which OSHA can issue citations to employers. One was the enterprise-wide violations, and the other one was for egregious violations. And the enterprise-wide violation creates a rebuttal presumption that a violation committed by an employer with multiple work sites is an enterprise-wide violation if there is evidence of a pattern of practice or the employer violates CALsavers rules on written policies and procedures. So this is where like your employee handbook comes handy, or your injury and illness prevention program that every employer is required to have comes in handy to make sure that you are in compliance with all CALsavers rules and are not inadvertently setting yourself up for potential citations with CALsavers. Now, the definition of egregious violation, there are several things that are considered under the egregious violation for an employee to be cited with a violation. So, for example, if the employer intentionally, through conscious voluntary action or inaction, made no reasonable effort to eliminate any hazards, or if they resulted in worker fatalities, a worksite catastrophe, or large numbers of injuries or illnesses, they resulted in persistently high rates of injury or illnesses, the employer has an extensive history of prior violations, the employer intentionally disregarded their health and safety responsibilities, the employer's conduct amounts to bad faith in the performance of their duties, or the employer has committed a large number of violations so as to significantly undermine the effectiveness of any safety and health program that may be in place. So if any of those criteria are met, then OSHA could potentially give you a citation for a violation of their rules. And they actually have ramped up their auditing of employers in compliance with COVID-19 regulations, but they're also, once they are there at your work site, they're also looking at other safety hazards, right? So right now it's a good time to get all of your policies in place and get your employees trained as well, because that is a requirement OSHA makes, is that you must provide training to your employees on all of your safety procedures and have documentation that you have provided that training as well. That could be something you can be given a citation for as well. If many of you remember back in November of 2020, it's all a blur now, but back in November of 2020, OSHA implemented the emergency temporary standard for COVID-19, which essentially required that all employers provide training and instruction in COVID-19 hazards, on employee symptom screening process, employee access to COVID-19 testing, plan to respond to COVID-19 cases in the workplace, employee face mask protocol, and plan for excluding COVID-19 cases from the workplace until the return to work criteria requirements are met. It created a requirement for employees to have a COVID-19 prevention program that includes a section for all these subsections that they have required. And in that emergency temporary standard, that plan, that COVID-19 prevention plan, has changed throughout the time since it was implemented. So as of now, and I say as of now because we have changes coming up as of this Friday on May 6th. But as of March 1 this year, there were no masking requirements in California for unvaccinated persons. And for OSHA, employers must allow employees to wear face coverings if they opt to, and provide a mask to unvaccinated employees for voluntary use, which is something that is going away as of May 6th. All employers must provide a mask to all employees for voluntary use. And something new as well that was that had been changed in the last revision of the ETS, of the emergency temporary standard, was that employees were required to have, or employers were required to have a mask that didn't allow any light to pass through when it was held up against the light source. And that is going to be removed as of May 6th. Many employers complained that even the N95s didn't meet that requirement, and they were struggling with compliance in this area. So good news is that is actually something that's going away as of May 6th, but employers must act cautiously when it comes to the face coverings, although they're no longer required, they're optional, voluntary. You must consider special circumstances. For example, if you have an exposure of COVID-19 case, or if you have an outbreak, or if you have close contacts, right, you may need to reinstitute your face covering procedure protocol to keep the employees safe. And it's important to make the distinction of OSHA requirements and also what the local health departments are requiring, because OSHA is now going to be deferring more to the California Department of Health to align their emergency temporary standards changes. And what the California Department of Health is doing is that they are also deferring to the local health departments as well. So, you kind of have to go through a process or through layers to figure out which requirements apply to you. But generally in LA County, masks are no longer required. However, the communication from the health department, the LA County health official, has been that it's strongly recommended for employees to continue to wear a mask, especially for those that work indoors in close proximity. For example, like in restaurants, in the kitchen, right? If employees are in close proximity, you still want them to wear a mask to make sure that you're keeping them safe and keeping the public safe. Now with testing, there was a change that went through with the last revision of the ETS that applied back in January of this year. So employees that had been exposed to COVID-19 tests must be tested free of charge during working hours. Or they must have been tested if there was a need for a test to keep them working or returning to work sooner on or after day 5 when in quarantine or isolation, or those that were not fully vaccinated and asymptomatic, right? So that is actually, as of May 6th, going to be changing. The testing is to be made available to any employee who exhibits symptoms regardless of their vaccination status. A few other changes that are going to affect as of May 6th is that self-administered tests are going to be allowed, or going to be okayed only if verification of results can be provided. Previously, it was that self-administered tests had to be read by a healthcare professional. But now there's a little bit more leeway as to how those tests can be administered. If the person, for example, can right after testing, take a picture and send that to the employer to provide verification, that is now allowed. Something else that's going away from the rules, and believe it or not, I was actually a little bit shocked when I saw this, but but that's what the law states, is that the cleaning and disinfection rules are now eliminated from the ETS. And they're aligning the definition of close contact with the definition that the California Department of Health provides, which is someone who's spent 15 minutes or more within 6 feet of an individual with COVID-19 infection during their infectious period, which includes at a minimum the 48 hours before the individual develops symptoms. So again, a lot of the changes that CalOSHA made to the emergency temporary standard are going to be aligning with the California Department of Public Health. However, you also want to double check that you're being in compliance with the local health departments for the county, or even for the city, to make sure that you don't miss anything that you're in compliance with. Now, we have state minimum wage that changes every January 1 of every year. As of this year, businesses with 25 or fewer employers have a minimum wage of $14 per hour. Those with 26 or more employees have a minimum wage with $15 per hour. We also had local ordinances. In Southern California, there's also a myriad of ordinances in Northern California. I'm not sure if anyone does business in Northern California, but if you do, just know that there are the majority of cities in the Bay Area do have their own minimum wage requirements as well. But here are some of the local minimum wage requirements for the city of Pasadena, Malibu, Santa Monica, and city of Los Angeles. We are currently at $15 an hour. For West Hollywood, as of July 1 of last year, this is the latest minimum wage ordinance, the latest city to adopt a minimum wage ordinance. So last year, as of July 1, it was $15 an hour for employers with 25 or less employees, $15.50 for those with 26 or more employees. And that is going to change as of July 1st. A lot of the cities are going to be increasing the minimum wage. West Hollywood is going to go up 50 cents for each one for those with 25 and 26 employees. City of Los Angeles is going to be implementing a minimum wage of $16.04. City of Pasadena will be $16.11. City of Santa Monica will be $15.96. And unincorporated LA County will be $15.96. I know this can be a little bit confusing because a lot of people think LA County is all of the cities in LA, but it's only the unincorporated areas, unincorporated cities and neighborhoods of LA County. We also had a supplemental paid sick leave for COVID-19 in the state of California. So if many of you are probably aware, there was already an existing paid sick leave for California, which requires all employers to provide at least 3 days or a minimum of 24 hours to all employees and applies to all employers of any size, even with one employee. When COVID-19 hit, there were several laws that went through. One of them was the COVID-19 supplemental paid sick leave, which provided an additional bank to employees to take paid sick time for reasons related to COVID-19, right? So this law had expired back on September 30th of last year. And as of February 19, it was readopted and became effective retroactively as of January 1. And it provides a brand new bank for employees to take up to 80 hours of paid sick leave for full-time employees and a prorated amount for part-time employees. They also can take paid sick leave, COVID-19 supplemental paid sick leave, to take care of a family member, and that is child, parent, either adoptive, step-parent, or legal guardian, spouse, registered domestic partner, grandparent, grandchild, and sibling. And again, it also provides paid sick leave for reasons to take the COVID-19 vaccine or to recuperate from taking the vaccine. And there is more guidance on the Department of Industrial Relations website. I've included the link here for the latest and greatest because they're always changing their guidance and their frequently asked questions. So if you do have some questions about this, you're not sure, I encourage you to check out their website. Now we also have in the city of in the county of Los Angeles, and this is again, unincorporated LA County. We also have a COVID-19 supplemental paid sick leave that applies to employers with at least 20, to all employers, not those with 26 or more, but to all employers. And it's set to expire 2 calendar weeks after the expiration of the COVID-19 local emergency. And eligible employees are those that perform any work within the geographic boundaries of unincorporated LA counties. If you have any employees that perform any work in those areas, this supplemental paid sick leave will apply to them. You must comply with providing the hours that the law requires. And it excludes healthcare providers and emergency responders. But the leave entitlements are 80 hours of supplemental paid sick leave, and then part-time employees get a prorated amount of no greater than the average of 2 weeks pay from the effective date of the paid sick leave law through the expiration of the paid sick leave law. So if you have any part-time employees, you have to constantly recalculate what that amount is going to be paid out to them. And if an employee had already exhausted their prior supplemental paid sick leave or previously issued FFCRA that was passed back in 2020, they're not entitled to a new bank unless you are an employer with 26 or more employees. Then the California law will apply to you to comply with that. So one thing to keep in mind there. Now we're running out of time, so I will be brief on the upcoming compliance requirements. CALsavers Retirement Savings Program is a law that went through a couple years ago, and it phased in the employers to comply with providing a retirement plan to its employees, starting with employers with at least 100 employees, and then last year was those with 50 employees, and this year is going to be those with at least 5 employees that must register with CALsavers by June 30th of this year if you do not already provide a retirement plan for employees. So you're not required to contribute to the plan, but what you're required to do is you're required to register with the state with CALsavers. And essentially what you're doing is you're coordinating the deductions from the employee's paycheck to be sent to their retirement plan with the state. So there's no cost to you. All you're doing is coordination of transferring those deductions to CALsavers. Employees actually can opt out on their website if they wish to. So they can go to calsavers.com and opt out. But as an employer, you must register with them by no later than June 30th. And also another upcoming compliance requirement is with the I-9 employment eligibility form. As many of you know, when you start a new job or you hire any employer, federal law requires you to verify that person's employment eligibility or employment authorization via them providing one of several documents that are included in their list of acceptable documents to establish both identity and work authorization. During COVID-19, employers were allowed to virtually conduct the verification of the documents. Normally, employers are required to actually view the document in its face value. But with COVID-19, we're not able to do that. So USCIS did allow employers to verify those documents virtually. That has expired as of May 1, and employers can no longer accept List B employment eligibility on expired documents. That was another exemption that they have provided, was that normally documents cannot be expired, but due to the closure of many agencies that were issuing the issued documents, they were allowing employees to accept expired documents. That has also expired. And as of July 31st of this year, all employers must conform and must comply with re-verifying those documents and making sure that all their I-9 information is in compliance with the regular I-9 regulations or regular I-9 rules. So anything, they will need to audit anything between May 1st through April 30th of this year to make sure that they are in compliance, and you may need to re-verify those documents. And with that in mind, I will close it out. I hope you had 1 or 2 key takeaways of the things we've covered: employment regulations, an update on OSHA, minimum wage changes, COVID-19 basically requirements, and the upcoming changes. So I will open it up for questions now. Lori, if we have any.
Wow, thank you, Xiomara. This was amazing.
Yes.
The amount of information you disseminated was just incredible. We've got a few minutes for a couple questions, and then we have some announcements before we close out. Joan, I see your hand up. Go ahead.
So God bless you for having to even have half of that in your head. I can't believe my head hurts. But I just, the majority of the businesses that we work with are small businesses. They don't have an HR department. They don't have an HR person. So I'm assuming SBDC can help them hopefully with that. They also had, well, that's good to know. They also had an issue during COVID where people became creative and offered signing bonuses and Netflix subscriptions. And when they didn't continue them, then the employee was leaving the company and threatening, you know, to cause problems. What does the employer do with that? I mean, this is a small business. What do they do?
To retain the employees?
Yes, to retain them.
Yeah, I mean, right now, the main thing for employers the main thing employees are looking for is that flexibility. And that really is not a negotiable for them. Okay, so they got used to working from home. They realized that they were able to better manage their home and family life. And they're really looking for that flexibility. So that would be my advice. If there is anything you can do to provide greater flexibility for employees, and flexibility may not work for everybody, but it may be like providing only certain days that the employees work. So instead of having someone being a full-time employee, maybe you provide them with just 4 days of the week that they are working, providing them extra time off. That is what's going a long way with attracting and retaining employees, is still having that flexibility. And I know the majority of employees, that's what they're looking for. But again, it may not work for everyone. So it's finding creative ways depending on your operations, right? So finding if someone is a full-time employee, but they are okay not working a full-time shift, right, or a full-time schedule, then it's a matter of figuring out, okay, can they work only 4 days? Or can you do a split shift, right? Can they come a few hours in the morning, or can they come a few hours in the afternoon? Those are the things to consider. Again, it will vary for everybody depending on operations. But I will tell you that is the theme out there for employees, is that they want that flexibility, and that's really not negotiable. So anything you can do to provide that will go a long way.
Okay, so but the employers, I'll end it with this, the employers can reach out to you with this email that you've got on the screen?
Yeah, absolutely. You can reach out to me, schedule an appointment with our admin coordinator, Annie. She is the one that gets the emails that come through this email address, sbdc@pasadena.edu. Yeah, anyone can schedule an appointment with me or with one of the other advisors. Again, it's all free. So might as well take advantage of the resources.
Okay, thank you so much. Appreciate it.
You're welcome.
Anybody else have questions?
Oh, yeah. I've got.
Laura?
All right. On CALsavers, can you explain to me what's the rule? If 5 or more, is it mandatory that you offer all employees, or is it a requirement that the state is requiring this?
Yeah, so it's a requirement the state has implemented, right? So years back, again, this was another sequel law. So years back, they implemented this law. They realized that Social Security might not be around for much longer and people are not saving enough. So they implemented this law to essentially get employees to save up for their retirement. And what they're doing, what they're asking the employers or mandating for the employers to do is to register with CALsavers so that they can facilitate the process of employees actually saving up for their retirement plan, for a retirement plan. And again, it doesn't need to be a plan that employers match. They don't have to make contributions, but rather it's the employee saving, having their own retirement plan, if you will.
So it's just a requirement that we register.
Right.
But if an employee chooses not to contribute, it's not a requirement on their part. So the only, as an employer, the only thing you need to do is register.
Right, that's correct.
And then it's up to the employees to contribute. And if they do, if you have 5 or more employees and only one wants to contribute.
Yeah, that they can choose to opt out on the website. Like you can't make it mandatory for them because a lot of people might not be able to, you know, they may have tight budgets and they may not be able to contribute right away. So they have the option to opt out. But if you have at least one employee that's still going to be contributing, then you're still going to be administering that coordination of wages that you're deducting from their pay to send them over or transfer them to CALsavers into their retirement plan.
So it's our obligation then, if they choose to save whatever the amount is, as an employer, we're responsible to collect that and distribute it and manage it.
Yes.
Okay, I don't like that. Okay, go ahead.
Hi, this is Charles. I have a quick question. Going back on one of your slides on the SB 572, and I believe it's if there were violations, and it's going back. Sorry about that.
It's okay, no worries. Okay.
There it is.
Okay, so you're saying allows, a lien to be placed on real property to recover penalties owed on violation of labor code. Now, we have insurance, but I would take this as punitive damages. So if someone's sued for punitive damages and labeled a person, usually our insurances won't pay for punitive. So is that basically what we're saying here for punitive damages?
This is for penalties owed on wages. So the labor, so the labor commissioner issues penalties mainly for anything owed on wages. So they can issue liquidated damages for the employee, but they will also enforce the labor code and the wage order, the wage orders for each that apply to each employer. So there are penalties. So let me backtrack a little bit. So every employer is covered under a wage order that California implements. There's 17 of them, depending on your industry and your occupation. And that wage order basically stipulates how it tells the employer how they need to be paying employees for overtime, for double time, meal periods, etc. And it also issues penalties for not complying with how you're supposed to pay employees. So that's what this is, that's where this would apply, is that if an employer didn't pay the employees properly, right, they're going to be issued penalties for not complying with that wage order. And say, for example, the employer for some reason doesn't pay for those penalties or does away with not paying for them. Now the labor commissioner can come after their real property.
Gotcha.
Yeah.
So it's only the employer's real property, not the individual.
Right.
Necessary. Okay. I just
Right.
want to just clarify that. Okay, great. Now let me ask you, going back to this CALsavers that Sam was talking about, and you talked about, and that's my last question. Can anyone, let's just say I have 50 some employees. So, and about 90% of them are in our 401k plan. So it's no problem. We do a match and all of that. But if someone had extra money, can they invest money with CalSavers?
You register as an employer, right? So if you already provide a retirement plan, then you're not required to
Right.
register with CalSavers because you're already providing a retirement plan for them. But I don't think that there's anything that would preclude you from registering with them if you wanted to. And then if an employer wanted to save up,
Right.
for an additional retirement account, I think they would be able to. But let me do a little bit more digging, if I
Okay.
may, and follow up with Lori on that.
Yeah,
I
because
think,
what I'm actually looking at, my company also gave a couple of us executives 457F plans.
Mhm,
But what we don't have is a 457B plan. And a B plan was going to be utilized for overages. Like, for instance, my 401k plan will exhaust itself for me making contributions in August because, the cap, right?
mhm,
So I'm going to have from August all the way to December to either put this money in a Roth IRA, the overage, or look for something like this and stack some money in CalSavers plan.
mhm.
So if you could look something
Yeah.
up for me and get back with Lori. Lori, I know Lori will call me. And that'll be good because I can pass that information on to some of my executives also that fall under that same problem.
Yeah,
Okay.
I will dig a little bit more on that. But
Okay,
yeah,
great.
my instinct tells me that, there's nothing that would prevent an employer from registering and
Right.
participating if they wanted to. But yeah, let me dig a little bit more.
Okay, good deal.
Great. Wow. I think we're just about out of time. If anybody else has any questions or comments or wants more information, please let me know. Xiomara's contact information is also available. And I know this is just the tip of the iceberg as far as some of the HR policies that come down. I was sharing with her before the call started that we sell HR required notices posters and through CalChamber, and they usually come out the end of December. Well, this year they weren't even printed and sent until after the beginning of January because there were so many last minute changes. So it's an ever evolving world. And as Joan alluded to, small businesses just don't have the time to even know about these laws. So this is really, really vital information. I'm going to stop recording. And then I do know that